you are going to pull up the grant deed. That's the first thing you're going to do. Okay. So let's see. Can you all see my Microsoft Word? Thumbs up. Yes. Yes.
Yes. Yes.
Okay. Great. All right. So look. First thing you're going to do when a homeowner passes away, you're going to pull up the grant deed. Okay. You're going to pull up the grant deed, and the grant deed is going to lead you in two ways. One is it's in the homeowner's name. Okay. Homeowner passed away. It's under the homeowner's name. The other one is going to be, it's going to be in a trust. The other one is going to be in a trust. Okay. So let's do the easy one first. My mom passed away. Immediately, you're going to call up Pacific Coast Title and says, hey, you know, can you give me the grant deed, right? Oh, and by the way, I want to thank Pacific Coast Title. I want to thank Jorge specifically for inviting me on this terrific training. Okay, so the first thing you do, homeowner passed away, you're going to call up Pacific Coast Title, get the grant deed. And if the grant deed shows the house is in a trust, hallelujah, there is no probate needed. Okay, so let's say the house is in a trust. Mom has 4 children. Who has the power to sign your listing agreement, guys? Mom died. You pull the grant deed. The house is in the trust. Mom has 4 children. Which of the 4 has the power to sign your paperwork? The answer to sign your listing agreement, the answer is the successor trustee. Okay? You're going to flip through the pages of the trust. So the trust normally is going to be in a binder like this. You're going to ask for that, you know, have the children give you a copy of the trust, give you a copy of the trust. You're going to flip through the trust and you're going to find the word successor trustee. You're going to find the word successor trustee. Whichever one is the successor trustee, that individual has the power to sign your listing agreement immediately. No probate needed. Obviously, you can sell the house. Now, you ask the children to look for the trust. Where will they find the trust? All right, so please look at your mom and dad's house to find a copy of the trust. Okay, so it's in a binder like this, and normally they'll find it. So let's say they look at mom and dad's house. Mom did the trust about 20, 30 years ago. They cannot find a copy of the trust. What do we do now? What do we do now? Call the lawyer, right? Some of you says, hey, call the lawyer. You call the lawyer's dead. God damn it, what good is he, right? He never told me he's gonna die. What? Oh, what do we do now? The house is in a trust. God damn it, there should be no probate. But we cannot find a copy of the trust. What are you gonna do, right? Because if you don't have a copy of the trust, how will you know which of the 4 children is the successor trustee to sign your listing agreement? How will title know that this is the appropriate El Jefe to sign your listing agreement, right? So if you lose a copy of the trust, welcome to probate, right? Then I have to go to court and says, hey, judge, you know, we don't know what the trust is because we don't have a copy of the trust. Okay? So the takeaway from this particular segment, please scan a copy of your trust, PDF format, right? Give it to your children, right? Because house burns down, you know, things happen, okay? If you don't have a copy of the trust, you're in trouble. All right, so that's that for the trust, okay? Now, if you are farming, let's say you wanted, when mom and dad pass away, the successor trustee is going to file an affidavit of death of a trustee, okay? So let's say if you were farming in the area, hey guys, baby boomers are going to be passing away. It's a sad truth, but it's happening, right? And COVID-19 may give it a nudge forward. All I'm saying is if you are farming and if you wanted the document that shows which homeowner passed away with a trust, that's known as the affidavit of death of a trustee, okay? So if mom and dad owns a trust, the trust says, hey, when I die, my son, um, Jorge is going to be the successor trustee. When he takes over, he immediately files an affidavit of death, okay? So if you can get your hand on that document, you can use that to farm, okay? So that's what the affidavit of death of a trustee is. All right, now next. Just to finish the trust subject, mom bought the house for $100,000 and now it's worth $1 million. If you want the property tax to stay the same, make sure your homeowner file this form right here. I'm going to show you on the screen. On the screen, this is your Proposition 50. Oh, let me see here. On the screen, this is your Proposition 58 here. Okay, let's see here. This is the reassessment between parent and child. Okay, so this is what I'm teaching you now is what the homeowner, the son or daughter should be doing. Mom passed away, mom has a trust. Make sure they file this form so that the property tax does not get increased. Even if they're going to sell the house with you, please file this form anyway, because it may take you 3 months, 6 months, 9 months, a year to sell this house. And in that span of time, they're going to reassess the property tax. So please make sure you file this form that you see on your screen. If you don't want to pay more taxes, please file this form that locks in, that keeps the property tax basis low, okay? The form you see on the screen, it's an estimate, is your Proposition 58, okay? This very next form here, Proposition 193, from grandparent to grandchildren, okay? So make sure that you have these two forms, well, even for yourself, okay? So everything that I'm teaching you today, it's going to apply to your client. It's going to apply to you as well too. Your mom, dad passed away. You're getting this house. If you're going to live there, make sure you file this form so you can keep the property tax low. Okay, so that's property tax. Okay, that's key. Now, so let me just back up for 1 second. When you are doing your trust, your client or you should also have a durable power of attorney, And why is a durable power of attorney important is this. So let's say a married couple, husband and wife, comes to see you. The wife says, please sell our house. We don't need it anymore. My husband has dementia. My husband has Alzheimer's. Can you sell the house? So the wife goes and signs your listing agreement. Can the husband sign your listing agreement? He has dementia. He has Alzheimer's. The answer is no. If a husband has dementia and he does not have a power of attorney, specifically a durable power of attorney, then it's going to lead you into conservatorship. You don't want conservatorship. Believe me, conservatorship it costs a lot of money. It's a court hearing to say your husband is crazy. Your husband is mentally incapacitated. You don't want that, okay? So make sure that your husband, your wife has a durable power of attorney that says, hey, if I become incapacitated, I let my wife, my husband, my son, my daughter can sign my name on my behalf. That's called a durable power of attorney, okay? All right. So critical, make sure your trust has that. Sort of a good component of a good trust, a good component of this binder is called an estate planning binder. In this binder, you ought to have a revocable living trust. You ought to have a durable power of attorney. You ought to have an advanced health care directive. You ought to have a pour-over will. What is a pour-over will? Let's talk about it. I said, when mom passed away, you pull the grandee, all right? And so let's say they give you this binder. Mom passed away, they give this binder. And this binder has, you see a copy of the trust, and you see the original grand deed of the house in the trust. You're feeling great. You're about to close escrow. Nelson calls you and says, hey, this house is not in the trust. The daughter says, oh, my mom refinanced it because I needed money to get married. She financed my wedding. But when she refinanced the house, she forgot to put the house back in the trust. Ay, ay, ay. What do we do now, right? Mom is dead. She had a trust. She refinanced the house. It wasn't put back into the trust. So what do we do? Do we need a probate? The answer is no if you have something called a pour over will. It's a very specific, special will that says if I forget to put something in my trust, aka my house, the pour over will go ahead. We can use that legal document, the pour over will, to do what we call a Hegstead petition. To do a Hegstead petition that basically says, hey, judge, the homeowner intended to avoid probate. Hey, judge, will you sign this piece of paper saying that that house is part of the trust? Okay, that's called a Hegstead petition, and that's how you can avoid a probate in that situation where it's a refinance situation. Mom did a trust. The house number one is in the trust. House number two, when she bought house number two, was not in the trust. You need that. Okay, it's called a Hegstead petition, a pour over will. Okay, all right. So a good component of a good trust, make sure you have all this. All right. Okay, so let us move back to sort of our outline. So now, I kind of cover with you what to do when someone passes away with a trust. I sort of cover with you why a durable power of attorney is important to avoid conservatorship. Okay, so now let's talk about title vesting for a second. Let's talk about title vesting for a second. Because
hey, Paul.
Yes.
Could you put your notes on the screen? We see the form 193 or 58.
Oh,
that'd be
I'm
great.
So sorry. I'm so sorry. Thank you.
That's okay.
I'm so sorry. Yeah, I thought I was showing you this, the pour over will. Make sure you have it. The pour over will basically will help you avoid a probate in a situation where the damn house was in the trust, but it somehow got out of the trust due to a refinance. The pour over will will save the day. Okay. And then I said, hey, in your estate planning binder, make sure you have all this, please. Make sure you have a revocable living trust, a durable power of attorney, an advanced healthcare directive, a pour over will, a new grand deed. Okay. Yeah. All right. So now, a probate is nothing more than a title clearinghouse. All probate is this. You own a house. You as the seller signs the grand deed when you sell the house to someone. When you sell the house to the buyer, you sign the grand deed, right? Say yes, yes, right? So in a probate, you pass away, the house is under your name, and people always ask me, hey, is there a way to avoid a probate? The house under my mom's name, I'm the only child, and my mom left me a will. We have no trust, but my mom left me a will, and I'm the only son. If there's a will, isn't there a way to avoid a probate, right? A will does not avoid a probate. A will puts you into probate. When you look at the meaning of probate in Latin, it means to prove the will. Okay, so a will is no good. All right. So all a probate is a title vesting house. Okay, it's a title clearing house. when you go to buy a house, these are your options. These are your options that you see on the screen, okay? Do you see my Excel spreadsheet on the screen right here? You can do sole ownership. You can do tenant in common. You can do joint tenant. You can do community property or community property right of survivorship. You ought to know the difference now, right? You are a real estate professional. You're buying a house. If you are married, you should know, damn, what is the difference between community property versus community property with right of survivorship? What's the difference? We'll get into that. Okay, so when you're buying a house, these are your menu. These are your menu of how you can take title. You can put your house in a trust if you like. You can have an LLC, a corporation. You can do a revocable transfer on death. You can do community property, whereas survivorship, or just straight up community property or joint tenant. Let's look at some tax implication. Okay? So actually, let's do joint tenant real fast. Okay? Joint tenant. So let me give you sort of an example with joint tenant. Joint tenant can break your heart. Joint tenant will break your heart, and here's what I mean, okay? So let's say, oh, let me just hide this for 1 second. I will come back to this. So let's talk about joint tenant. So let's say, let's do an example. Let's say we have a very wealthy individual. Let's say her name is Maria. Maria is about 75 years old. She's 75 years old. She's buying a house in joint tenant. Okay? So she's 80 years old. She's going to buy a, let's say she's going to buy a $5 million house. Maria has a daughter from her prior marriage, okay? She's marrying this guy. His name is Rico Suave. He's 25 years old. His name is Rico Suave. He's 25 years old, okay? That $5 million is all Maria's money. So here's Rico Suave. That is, let me see. Do you see his picture or no? Let me just show you what Rico Suave looks like real fast. He doesn't, let me see here. Oh, let me see if I can show you a picture of Rico Suave. Give me 1 second. What happened to my, let's see here. Give me 1 second here. Let's see. Just wanted to, let's see here. So this, so she's buying a $5 million house. Okay? And so let's see here. Let me just show you a real, the $5 million house, the $5 million all belongs to her. Rico Suave doesn't have a penny to his name, but who cares? He has a six-pack, right? He has a six-pack. So the $5 million is all her money, is in joint tenant, right? 25 days later after her wedding, it's a happy ending for her with a smile on her face. She's in heaven. The house is in joint tenant. Who gets this house? He's been married for 25 freaking days. The $5 million is all her money. The house is in joint tenant. Who gets this house? Rico Suave gets it all, right? Because it's joint tenant. But that is so unfair. 25 days of marriage, come on. Rico Suave can't be that good, right? But joint tenant, by definition, all goes to him, okay? You say, stop it, Paul, stop it. People who have $5 million ain't that stupid, Paul, stop it. Okay, you're right. So Maria goes and marry, let's say Henry. Henry has, let's say Henry has a son from a prior marriage. Maria has a daughter from a prior marriage, and it's a beautiful marriage, 30-year marriage. They own 10 houses. They own 10 houses together. And they own it as joint tenant. Maria died first. Those houses in joint tenant, 10 houses, Maria died first. Henry dies of a broken heart. Can't live without Maria. Can't do it. Henry died. Those 10 houses, how is it split up? Maria died first. Henry dies after. Henry has a son from a prior marriage. Does all those 10 houses goes to Henry's son. Joint tenant, last one standing takes it all. Okay. I want you to walk away with this concept. In joint tenant, anything under joint tenant, last one standing takes it all. Okay. If you have something in joint tenant, when one person died, the other one automatically takes everything. Okay. So be careful with joint tenant. It's not good in the sense that it may have some unintended estate planning that you don't want to happen. Okay, so that's one thing. The other thing is taxes. Okay, so I'm also a CPA, so let me share some tax knowledge with you. Okay, so let's talk about taxes. Let's say husband and wife bought the house 40 years ago for 100 grand. Okay, do you all see my Excel spreadsheet? Yes. Okay. Husband and wife bought the house 40 years ago, let's say for 100 grand. Okay, and now it's worth $1 million. Now husband died, right? California law, husband always die first. That's California law, right, guys? Anthony, the manager, is saying, who is this guy teaching all this crazy law, right? Okay, husband died, house is too big, you sell a house for $1 million, okay? For the wife. Husband and wife bought the house for 100 grand. Now it's worth $1 million. Husband died, you sell the house for $1 million, okay? And it's under joint tenant. Here's how you calculate capital gain. Okay? The wife's 50% cost basis is $50,000. Why? Because she bought the house the married couple bought the house for 100 grand. The wife is still alive. You're selling for $1 million. So the wife's cost basis, 50% is only 50,000. The husband's cost basis, because of the step up basis, when he died, his half is $500,000. So we put $500,000 right here, right? So the capital gain calculation is $550,000 if it's in a joint tenant. But if it's under community property, it's a 100% step up in basis. So exact same example, the capital gain under joint tenant is $550. Exact same example in community property, it would be zero capital gain, okay? So very, very powerful concept. That's another reason why you don't want to do joint tenant, that you want to do community property, okay? Because community property, you get 100% step up in basis, okay? All right, so next, under both types of community property, the tax consequences are good under both types of community property. So the question you might have is, okay, well, what's the difference between community property straight up versus community property with right of survivorship? What's the difference? All right, let's talk about it. Okay? Let's talk about that. So now we're gonna hone in on the difference between community property versus community property with right of survivorship. So if the house is in a community property, just straight up community property only, the wife can go ahead and write a will and give her half to the pool boy because he cleans the pool so well. She can do that because that's her half. So in the community property, each spouse, they can write a will and give their half away. But under community property, with right of survivorship, that's called the I love you way of holding title. That's where neither party can will their half away. Okay, that is the main difference. Between community property versus community property with right of survivorship. Okay, all right. Going back to tax for one second, so we can just sort of complete this tax subject. There's something called the step-up basis, guys. Mom died. Mom bought the house for 100,000. When mom dies worth $1 million, the daughter always gets a step-up basis. Okay, it's mom's house. Mom bought it for 100 grand only. When mom passed away, it's worth $1 million. The daughter gets a step-up in basis. It's very powerful. That's called a step-up basis. So the way to take advantage of that is to put your house in a trust. Okay? And then when you pass away, the house will go to your son, your daughter, and they will get a step up in basis. Okay? They don't have to pay any taxes. So that's called a step up in basis. Okay? Now, let me see if I can sort of, so if you have a trust, after you pass away, it avoids probate, and your son or daughter will get a step up in basis, and they don't have to pay any taxes. All right. So, let's see. So Nicole says, I have to get a trust. You know, Paul Horn, he's obnoxious. Why do I need to go see him to get a damn trust? I only have one daughter. I'm just going to put my daughter on the grand deed. When I die, there's no probate. Nah, screw you, Paul Horn. I don't need to go see you for a trust. See? What do you got to think about that? Forget goddamn Paul Horn. We don't need a goddamn trust. I only have one son, one daughter. Just put his or her name on the grand deed. When I die, the house goes to that son, that daughter. Yay! We've succeeded in screwing the lawyer. Yes! What do you guys think about that? Don't do that. Don't do that, because when you put your son or daughter on the grand deed, you destroy the step-up basis. No more step-up basis. If your son or daughter, you only get the step-up basis of not paying any capital gain when your mom and dad pass away, only if your name is not on the grand deed, son or daughter. If you put your son or daughter on the grand deed while you are alive, there is no step-up basis. You put your son, your daughter on the grand deed because you want to make America great again by paying more taxes, go ahead. Okay? Right? But if you want to save your daughter or son some money, okay, get a trust, right? It still goes to your dear daughter, but she gets a step up in basis. Okay? All right. So that's the lesson there. So the moral of the story is, a trust. A trust is important for another reason. Let me show you this reason I think is pretty important. Let me show you this real life example. I have a lot of probate clients. So in probate, when you pass away, let me see here. In probate, let me see if I can show you this. Give me 1 second. Let me see if I can show you something I think that's really important. Let me see. Let's see here. Okay, so what I want to talk about is Medi-Cal. If you look at your screen, this is a real example. This is Medi-Cal, okay? You see the word Medi-Cal right here? Oh, let me see here, Medi-Cal. See that? Notice of Medi-Cal right here, Medi-Cal? For $249,000. Mom passed away. It went to probate. Mom used Medi-Cal, $249,000, 724 cents. Medi-Cal want their money back. Okay? If you use Medi-Cal want their money back. But we can avoid that now. Starting January 1st of 2017, The new law says if you don't want to pay Medi-Cal back, just do two things. Just do two things. Starting January 1st of 2017, if you don't want this to happen to you, if you don't want to pay back $250,000 to Medi-Cal, just do two things. Guys, look at me. Just do two things. Get a trust, and then you can die. That's it. Get a trust. When you have a trust, you avoid probate. When you avoid probate, no Medi-Cal recovery. It's as simple as that, guys. It's as simple as that. You don't want to pay Medi-Cal back? It's easy. Get a trust, then you can go to heaven. That's it. It doesn't matter if you've been using Medi-Cal for the last 20 years. Doesn't matter. Get a trust, and then you can say goodbye, whatever you want to do, right? Get a trust. Now, get a trust, and then you can die. That's it. It's that simple, okay? Such valuable information for your client, right? The only reason why your client don't have a trust is that they're never gonna die, right? Those are the only people that don't need a goddamn trust. They're never gonna die. They're Superman, Superwoman, right? All right, enough of that, okay? Okay, so, all right.
Paul, actually, we have a question, Paul, really quick before we move on.
Yes.
We got a question from, does this apply to a special needs trust as well?
Okay, so what a special needs trust is this? If you are on some sort of governmental benefits, right, where you are on Medi-Cal, you're getting, you're disabled, you're getting government assistance, government money. Sometimes we put your fund, your asset into a special needs trust so that it's not counted towards your eligibility. So the answer is yes. The answer is yes. If you have a house, a primary house, if you have a primary house, most of the time, probably all of the time, the government does not count that as an asset because the government wants you to live in that house so we don't have to pay for your governmental convalescent assisted living, right? So if you have one main house, no problem. We encourage you to have one main house. We encourage you to live in your house so you don't have to burden us taxpayer with fronting your costs at your monthly convalescent home. Okay? Yeah, so the answer is yes. Get a trust, no Medi-Cal recovery. Okay? All right, so let's move on to a probate. Let's move on to probate. Let's talk about probate now. Let's talk about probate. Oh, let me see here. Let me sort of find my screen. Oh, where am I? Let's see here. Let's see here. Let's get into probate. Okay, so in probate, so let's say you pull up the grand deed, and unfortunately it's under mom's name, okay? So, or dad's name. Dad passed away, mom passed away, you pull the grand deed, and it's under mom and dad's name. If it's under mom and dad's name, it's always gonna be in probate, okay? If the deceased name is on the grand deed, it's gonna be in probate. You know why? People always ask me, oh man, can I avoid a probate? Come on, is there a way? I say, yes, there's a way. You don't have a trust, there's one way to avoid a probate. You go to heaven, you find mom, you find dad to have them sign the grand deed. So you're gonna avoid a probate. If you can find an elevator to heaven, great. If you cannot find an elevator to heaven and mom has no trust, it's a probate, okay? So in a probate, what you want to know in a probate is this: whether that probate is full authority or limited authority, okay? So the critical knowledge to have in a probate transaction is a probate, mom dies under mom's name, it's a probate, but the judge has granted the son or daughter, known as the personal representative, full authority or limited authority, okay? If it's full authority.
So Paul, sorry to interrupt you. We do have a question before we move on. Do you also look at people's trust by other attorneys to make sure they're correct?
Nelson, that's garbage. If it's not done by Paul Horn, forget it.
Yes. Okay.
Yeah.
Let me finish the question. With that being said, are there a lot of mistakes by other trust attorneys that you might find?
Hey, look. let me just share something with you, okay? Let me just share something with you. Oh, let me just share something with you real fast. If you, let me see here. Let me just share something with you real fast. This is sort of a public announcement. It's sort of always go to the state bar. Always go to the state bar, okay? When you go to the state bar, there's something called certified legal specialty. The state bar certifies certain individual to let you guys know the difference in the amateur and the professional. So for example, like myself, I do nothing but just probate and trust, okay? So you don't have to use me, whoever you use, please make sure that they are a certified specialist. Go to the state bar, and if they are a legal, you cannot go wrong by going with someone who's a certified specialist in this area, okay? Yeah, so to answer your question, absolutely, Nelson. Always, because look, if you have a mistake on your trust, I'm sorry, there's no mulligan. You cannot come by and says, hey God, hey Jesus, I didn't mean to let my cousin Jose do my trust. I'm sorry. Can I just come back and fix my trust? No, right? You're dead. Bye-bye. See you later. Okay. All right. So anyway, not to sidetrack, please, right? This is your last contract. This trust says, hey, it goes to my daughter, but if my daughter gets a divorce, her SOB, ex-husband doesn't get this house, okay? It protects your children even from divorces too. It passes the house to your grandchildren, okay? So anyway, a good trust will do all that for you, okay? All right, so back to probate. My apologies, Anthony. He said in the beginning, he said, let me set some strict rule. And I thought he was going to say no cursing, but you didn't say that, so I'm free to do it. Just kidding. All right, so back to probate, okay? Back to probate. The key in probate to know is, hey, that particular probate that you're listing, that particular probate that you're buying for your client, that you're representing, is it full authority? Is it full authority or is it limited authority? There's only two types of authority: full authority and limited authority. That's it, okay? If it's full authority, it is really easy. If it's full authority, Pacific Coast Title is going to say, hey, I only need 3 documents to close escrow. All I need is letters. All I need is order for probate, okay? All I need is the notice of proposed action. You get me these 3 documents, Pacific Coast Title says we're going to close your probate without court confirmation, without the court allowing to sell, nothing. All you got is give me these 3 things. Notice, so letters, order for probate, notice of proposed action, okay? So that's it, guys. If it's full authority, you only need 3 documents: letters, orders, and notice of proposed action. So letters looks like this. If it's full authority, all you need to do is give your title company, give escrow these 3 documents. Oh, give escrow these 3 documents. Letters looks like this. It's a form, okay? It's a form, and it looks like this, guys, on your screen. It's called letters, exactly like that. That's 1 document, okay? Second, you give title or escrow this document called orders for probate. This is the 2nd document. The 3rd document you give to escrow is this document right here, notice of proposed action. That's it. You give escrow, you give title, these 3 documents, you can close your probate just like a regular transaction, and you can close that probate transaction 3 months from the day that I start the probate. Probate normally takes 1 year to do. But if you have full authority, you can close the probate transaction in about 3 months. When we start a probate, the son or daughter that wants to be in charge is known as the personal representative. And 2 months later, letters and order comes out. From the day I start the probate, from day 1 that I start the probate, 2 months later, your client gets this form number 1. Your client gets this form number 2. And then you give me the probate purchase agreement. You give me the probate agreement saying, hey, we're going to sell this house for $500,000, for example. And then I prepare something called a notice of proposed action. We're going to send this form proposing, we're going to let all the other children know, the other brother and sister know that we're going to sell this house for $500,000. 15 days later, they don't object. That's it. That's it. You close escrow. It's as simple as that. You don't need court's permission. You don't need it. It mimics a regular escrow. Let me repeat that. Probate with full authority acts just like a regular transaction. The only difference is you get title these 3 documents: letters, orders, notice of proposed action. That's it. Letters and orders you get 2 months. You get 2 months after I start the probate. Once I start the probate, about 2 months later, I start the probate. 2 months later, you get letters and orders. Like you see on your screen, 2 months later, I get order and letters. When I start the probate, you can go ahead and start marketing this house, find a buyer. As I'm doing the legal paperwork to get your son or daughter approved, by the time I get your son or daughter approved, we're at the 2-month mark where letters and order comes out. At that time, you give me a probate purchase agreement. I then generate form number 3, which is known as the notice of proposed action. I mail it out to all the son and daughter. 15 days later, they don't object. You take these 3 documents, you give it to escrow. Escrow gives it the title. Bam, game over. Escrow closed. You get your commission. What is your commission? If it's full authority, you can do 6%. If it's full authority, you can do 6%. Okay. If it's limited authority, you're probably going to be limited to 5%.
Yes, Angelita.
Hola. Someone say something? Okay, so that's full authority. Okay. Limited authority. Let's talk about limited authority. So if a probate is limited
Actually,
authority.
Paul, sorry, this is Anthony. Before we move on, I know somebody actually had a question regarding trust. If the trust is unable to be found by the family and they don't know who the attorney is that prepared it, what's the process that they would need to take?
So if we cannot find a copy of the trust, you cannot find the attorney. Who cares about the attorney? He might be dead, right? I don't want you to rely on the attorney. I want you to keep your own binder. I want you to make a copy of it. Screw the attorney. They die just like you. They probably die earlier than you, all the stress that we have, right? Anthony, it's going to go to probate. If you cannot find a copy of the trust, you cannot find the attorney, welcome to probate. Because how do we know what the trust says? How do we know who can sign the listing agreement? We have to rely on the court. The title can only issue good title if they feel comfortable. Yeah, the judge appointed, Nelson Sanchez to be the successor trustee, or the person, the personal representative of mom's estate. Okay, so Anthony, I think that answered the question. If you cannot find a copy of the trust, you cannot find a lawyer. The trust is not recorded anywhere. Okay, maybe that was the answer they were looking for. The trust is not a public record. It's not recorded anywhere. Yeah. So, all right. Let's talk about full authority. Let's talk about limited authority. Let's talk about limited authority. Let's talk about limited authority. All right, let's go here. Let's talk about limited authority. Let's see here. Limited authority. Let's see. Let's do this. Let's talk about limited authority. Let's do this. I'm going to show you sort of a little outline for limited authority. Let's see here. So let's see here. Limited authority. Okay, let's take a look. Let's take a look at limited. What's involved with limited authority? Okay, so let's go over that now. Limited authority. Here we go. Okay, so Let me just switch my screen. Let's go to limited authority. What are the rules involved? Okay, so it's a probate. It's limited authority, okay? So these are the steps that you take when it's limited authority in selling this house, in closing this limited authority probate transaction. Here are the steps. All right, so starting from step 0, from the day that I start the probate, 2 months later, letters and orders are issued. So this diagram that I showed you, still hold. 2 months later, even if it's limited authority, 2 months later, letters and order comes out. Okay, so no matter what is full authority or limited authority, at the 2 month mark, letters and orders are issued. Okay, all right. So 2 month mark, letters and orders are issued, but it happens to be limited authority. Okay? If it's limited authority, you have to sell it for at least 90% of what the probate referee valued the house for. So if the probate referee valued the house for $500,000 and it's limited authority, you must sell it for at least $450,000. That's 90%, for example, multiply that by 500,000 is 450,000. If it's limited authority, you must sell it for at least 450. Okay. All right. So if it's limited authority, you must publish in the newspaper, hey, we're going to sell this house. That's just the law. You have to do it. Okay. If it's limited authority, you need a 10% deposit from the buyer. It's a 10% deposit. Okay. So it's limited authority, letters and order comes out, the probate referee value the house, you publish in a newspaper, only then can you accept an offer. Only then can you accept an offer with a 10% down. And then you tell the buyer, hey buyer, please clear all your contingency. How do you spell all? A-L-L, please clear all contingency. Once all contingency are clear, then you go to the probate attorney. The probate attorney will now fill out paperwork and says, hey judge, we're ready for you to confirm the sale. Does this sound familiar? Court confirmation for the court to confirm the sale of the house. Court confirmation only happens if it's limited authority. Okay. All right. So back up. A probate is started, letters and orders are out. It's limited authority. You must sell it for at least 90%. You got to publish it in a newspaper. After that, only then can you accept an offer with 10% down. You tell the buyer, please clear all contingency. Once the buyer clear all contingency, then the probate attorney will set a court date to confirm the sale. Court confirmation to confirm the sale. Okay. The listing agent, the buyer's agent, and the probate attorney will go to court. When they're in court that day, other people can show up to bid on the house, right? So the house is sold for $500,000. You want to bid on the house. You as a separate buyer, you represent a separate buyer. You bring that buyer to court. There is a formula that the court will follow to start the bidding number. The original offer is $500,000. But the bidding does not start at $501,000. There's a very specific formula called the overbidding formula, and it works like this. So exactly as you see on the screen, number one, the accepted offer is $500,000, for example. We take 10% of the first 10,000 is $1,000. We take 5% of the remaining, which is $500,000 minus $10,000 is $490. We take 5% of $490 is $24,500. We add up all the numbers in red. Do you see on your screen $500,000? Do you see $1,000? Do you see $24,500? You add up all these three numbers. The starting auction bid is $525,500. Okay. If you want to go to bid on this house, you must bring a 10% cashier check. Okay. All right. So, guys, I hope it's been helpful. We have 2 minutes to take questions. I can say a little bit longer if you like, up to Nelson, Anthony, and Jorge. So that is sort of sort of the rundown. Yes, did someone say something?
I have a question.
Yes.
Yes, you mentioned conservatorship. What is that?
Conservatorship is you are alive, you have dementia, you have Alzheimer's, you're still alive, but your brain is out. When you're still alive, but you're mentally checked out, dementia, Alzheimer's, because you're over 18, your parent cannot make decision for you, right? So you go to court. So the judge will appoint your wife, your daughter, your son as a conservator, Carlos, to be in charge of you. That is called conservatorship. Carlos, avoid conservatorship because it's embarrassing. The judge is going to say, is Carlos crazy? Did you let all of Carlos' cousin know to come to court to say he's not crazy? It's embarrassing. Conservatorship is hell. Don't do it. Get a durable power of attorney that says, hey, judge, please stay away from me. If I ever go cuckoo, I trust my wife to sign my name, or my son, my daughter, Carlos. That is conservatorship.
Thank you.
Mm-hmm.
Paul, can you share your information, your email, and where's your office located?
Yes. Okay. So, look, if you want to learn more about probate, go to this site. Go to learnprobate.com. Just as you see on the screen, learnprobate.com. I do have classes. That's where I take less coffee and I slow down a little bit. You know, I don't drink as much coffee. The jokes is not any more funnier, but you know. But yeah, go to this website. It's got all my information. And, you know, it's the stuff that I teach is real. You know, it happens to us. You know, it happens to you, to your client. So thank you so much, Pacific Coast Title, for having me. You know, thank you, Jorge, Nelson, Anthony. So let's take some questions, you know, if there are some questions.
Actually, Paul, I think you answered most of the questions throughout the class, and I did ask everyone to enter them in the chat. So I think most of the questions have been answered. You've been a wonderful speaker. You've been great, entertaining as always. Your jokes and your personality absolutely make the class. And thank you very, very, very much for doing this for us. And I know that your courses are phenomenal, and I think it'd be great for everybody to sign up and really learn probate. And like you said, those classes you do slow down a little bit, so you get a little bit more in depth. But we do appreciate you, and thank you so much for joining us today.
That's great. Thank you so much, guys.
Thank you.
Before we end, I'd like to remind everybody about our Title Tuesday for next week. We've got Shannon Horn with Digital Faces. He'll be hitting on social media topics like how to attract fans with your profiles, how to set up your link for bio for success, how to turn appointments virtual, how to make prospecting quarantine proof, and how to learn what attracts sellers. That's next Tuesday, July 14th at 1 p.m. And I'd also like to introduce Jorge Mesa with Pacific Coast Title. He's going to talk a little bit about his title tips for the week.
Well, guys, again, if you want to farm, there's two leads that I highly recommend. Number one, probates. Probates don't care about the rates. They don't care if the rate is low or high. Probates don't care if the market's crashing or is going up. Probates are always going to be there. So that's a good farm to have, probates. Second farm to have, absentee owners. Those guys, and I keep preaching this every week that when we do these trainings, the number went up. We're at almost 70% on open orders for absentee owners here at the title companies. 70% of our business is coming from absentee owners. Those guys that they own one or two properties that they're having a tough time paying because they lost their job or because the tenants are not paying the rent. So the only choice they have right now is to sell the house. So if you want to contact your title rep from Pacific Coast Title so they can put you in the right direction to get farming. And I'm going to give a few minutes to my dear friend, Javier Munoz from Downey Exterminators. Every week I do the same. I forgot about him. Javi, you want to say something about the termite business?
I'll keep it short. I'm sure everybody's busy. Good afternoon, Javier Munoz, Downey Exterminators. Just want to tell you for a reliable termite inspection, work completion at a reasonable price, look no further, Downey Exterminators. Thank you, Jorge. and Pacific Coast Title.
Thank you, guys. Well, don't please. Next week is gonna be great training. They're gonna show you how to do digital door knocking through social media. I'm gonna be there because I want to learn how to put this Zoom call into the Facebook, so Paul doesn't give me a hard time next time. I need to learn that. All right, guys. Thank you so much, and see you next week. Paul.
Thank you, guys.
Thank you so much.
Bye-bye.
Bye, guys.
Thank you, guys.
Thank you. Thank you, Jorge.
Thank you.
Thank you, guys. Analia, thank you. Tomasita,
Thank you, Jorge.
Thank you, Jorge.
Mario,
Thank you, Jorge. Thank you. See you next meeting.
thank you, guys. Thank you, Nelson.
Thank you,
Carlos.
Jorge.
Thank you, Ceci.
Me llamas, quiero hablar contigo, ¿ok? Te mandé un texto. Para marketing, para marketing.
5 minutes te llamo.
Cool. Take
Gracias.
care.
Gracias, Jorge.
Bye bye.
Gracias.
Thank you, Jorge.
Thank you so much.
Looking nice.
I don't know. Looking old
Haven't seen you in months.
since I left.
Yes.
5 months.
Gracias, Jorge.
José, ¿cómo estás?
All right.
Gusto verte.
Bien, gracias. Después te hablo. Gracias.
Perfecto.